that cover it, Alex?
Yeah, that should work, Mr. Chairman.
Okay.
You need a second?
Yeah, go ahead. You get a second?
Second, Chris
Yeah, I
McGrail.
got a second.
All right, we'll just do a roll call vote. All those in favor, Frederick Cassavant, aye.
Arthur Boyle, aye.
Chris McGrail, aye.
Okay, thank you, everybody.
Thank you.
Thank you.
All right. Let's get into our next one. All right, and we can reopen. This is another continued hearing, case 3-21, appeal of building inspector's letter, applicant Grissom Park Company LLP, 260-280 Oak Street. All right, who do we have for that?
Good evening. This is Kim Croa and Warren Baker for the applicant Grissom Park.
Okay.
Thank you.
So,
Do you have any questions before I begin, or do you want me to just?
no, I don't. Just ask Alex, with us continuing this other hearing, are we good to move on this one, the current one, with the cease and desist, which is concerning Sousa? Yeah.
Yeah, I mean, I think it's up to the board, but again, you want to be consider. I think you could probably take some testimony today, but you know, if you're going to issue a decision here, it probably should be consistent with how you're going to act on the Sousa matter. So it may make sense to continue this as well.
Okay, well, why don't we hear from the applicants, and then we can decide on continuing it or not.
Thank you. Yes, so we're here tonight on the December 14th letter from the building inspector. And in that letter, it's a...
Kim, I'm sorry, just to mention one thing. So apparently the audio, the live stream audio is now working again. At least that's what I'm told by one person who called in. So that's, I guess, hopefully a good thing for transparency and so forth.
Okay, thank you, Matt.
I apologize.
All right, go ahead, counsel.
So December 14th letter, the building inspector issued a cease and desist and notice of revoking the temporary occupancy permit that was issued for the Oak Street properties. And in that, he cited the section 57G1, which talks about how no building permit occupancy permit could be issued until a site plan approval has been granted, the appeal period has expired, and at the option of the board, all work has been completed to the satisfaction of the board. Now, I know that this board is well aware of some of the issues at the property, but it's entirely appropriate for the temporary certificate of occupancy for this property to continue. A temporary certificate is what the name denotes. It's temporary. It means that there's something outstanding that's working to be resolved, which is where we are right now. We did receive site plan approval back in July of 2017. The appeal period on that site plan approval passed. There were no appeals filed. The owner received building permits, built the buildings, the foundations of the buildings exactly where they were. Clearly, we've had an issue with the driveway entrance that was changed during that process. We understand our client was wrong to change that entrance without going back to the planning board. And we've apologized to the planning board. We've apologized for not following the steps. We've had 1.5 years of hearings of trying to correct that issue through a major modification of the site plan approval. We've engaged experts on our side and paid for experts on the town side to try to resolve that issue. And now we are in appeal of that issue, still trying to resolve it. So while there is an outstanding issue as far as layout of the particulars of the site, the construction of the buildings themselves were not constructed any different than what was approved. And the remedy, if there's a zoning issue, which we don't believe there is a zoning issue at the property, it's just a matter of getting a court to take a look at the site plan decision that was rendered by the planning board and taking a closer look at the evidence that was in front of the board. But even if there were a zoning issue there, the remedy is for the applicant to fix it. It isn't to kick people out of the building, and it isn't to require any sort of demolition or anything else. The remedy is to fix the problem, to focus on the goal. There's a host of cases out there, but one in particular, the owner built a building and he decided to make it another 11% bigger than the one that had been approved previously. And the neighbor, who actually was harmed by the change, the building was a lot closer and there was a very loud AC unit that was right next to her property, asked the court to have everybody kicked out and to have the 11% shaved off the building. And the court said, that's not the right way to approach this. The right way to approach this is to fix the problem, see if it can be approved with the way that it was built, and deal with it then. In contrast here, there is no abutter that's actually harmed by the changes. There's an abutter that's made a lot of noise to the changes with the site plan approval, but has also stated on the record at the planning board that they're not actually harmed. They're just looking to focus on the technical issues of the bylaw and, in our opinion, misconstrue them, but in any event has admitted more than once that he's not actually harmed by it. So we are asking the board tonight to reverse the decision, the December 14th letter, and to issue an opinion that the temporary certificate of occupancy should continue while the appeal from our site plan modification is pending. And depending on how that's resolved, take another look at it at that point.
Okay, thank you. Chris, you have any questions, comments?
I do not.
All right, Arthur?
Mr. Chairman, I'm wondering about the part that seems to be being left out is that the property owner apparently, and this was before my time, so I apologize if I don't have the steps right as they went correctly, but we're in essence having a petition for looking for forgiveness rather than permission. Is that pretty accurate?
That's one way to put it, yes.
I will add that this also is becoming a bit circular. The planning board, one of the reasons that they denied the site plan approval was because Sousa was in there and they had determined that that required some other approval. So Sousa came in and filed for a special permit, and that's now before this board. So it's in trying to tie everything up that we're just continuing to be in sort of a hold position, but we are attempting to resolve the issues. We're working hard on making the site a contributing site in Pembroke. It's a site that looks good, that was built in accordance with the building permits, except for this driveway issue that is becoming resolved and some other more ancillary site issues that have been discussed with this board at other hearings.
Okay. Mr. Denny, did you want to say anything briefly?
Thank you. I'll be very brief, Mr. Chairman. Again, one question I would ask through the chair is whether or not they now have leased another bay, a third bay to Mr. Sousa, because Mr. Sousa has two bays currently when the cease and desist letter went out. And now it's my understanding there's a third bay Mr. Sousa is now using. I was wondering if the applicant would shed any light to the board if they now expanded it to 3 bays.
Counsel, can you?
Yes, be happy to. Yes, Sousa has been operating out of the 2 bays for his automotive use. The site plan that's approved allows manufacturing, industrial, and storage. And Mr. Souza is using a third bay for storage only, which falls within the uses that are allowed.
Thank you. Mr. Chairman, fellow board members, the issue is what was granted with respect to the site plan. If you want to go back to 2017, what was set on the site plan layout was for industrial, manufacturing, and wholesale. That's what this board granted a special permit for in order for them to have the warehousing. And on that, on their own plan, which I think if this is going to get continued, happy to submit a certified copy for the board to understand how the parking requirements came up in that site plan. But it was one space for each employee on any shift. So if they have one employee, they have to have a parking space. And it said 2 employees per unit. So they only were allowed 2 employees per unit. Their numbers came up to 30. That's under the bylaw. They needed 30 based on the overhead doors that they have there. So they are providing on that current special site plan, parking for 32 spaces. Now I realize that the applicant prior, Mr. Souza, was saying, well, you know, we have ample parking spaces because they're over 43. No, there are 32 parking spaces. And there are other units that are being rented, which gets to the fundamental issue of a site plan. Do you have adequate parking? For warehousing, they do. But that's when they decided to allow a use without a special permit to be able to go in there. If they want to do that and allow it, then they can't allow other uses to be permitted in those other bays because they don't have adequate parking, which says under the special permit provision of the business 3 or business 2, you need to have sufficient parking and an approved site plan. The building inspector has said he's denied it because they don't have an approved site plan. If they want to go back to 2017, they can. You have warehousing. But instead, they've put in a different use. And to Mr. Boyle's point, they're asking forgiveness of this board yet again for doing something they weren't supposed to do. And that's why they're asking you folks to bless it. And the last point I want to make is this. As part of their submission, on the memorandum under page 5, section 4, it says Grissom Park's application did not request a change of use. They specifically said, and I quote, after the tenant received their building permit and built out their space, a question came up as to whether the use fell under the light industry category. There was never a building permit issued or requested by Mr. Souza. The only building permit that has been allowed was the original building of the warehouse. That is a mistruth. And that gets back to the fundamental issue. Tell the truth, tell the facts, and abide by them. And if you want to get a special permit, then make sure you have the adequate parking. Just make sure you have the adequate access. That's the whole fundamental point of a special or a site plan that the planning board reviews, just to ensure the safety. But they're not doing that. They're doing it backwards. And then they come back and say, well, poor Mr. Souza, which I do feel bad for him. He's in a tight position because they didn't get the permission. They don't have the adequate site plan to put the use there. And now they're forcing you folks to be the bad guys because of what they decided to do for monetary reasons. And last point is this. They got their temporary occupancy permit under the bylaw and building permit, and it was extended for over 6 months, beyond that actually. And now they're asking you to extend it further. And Mr. Very has said no in this case. And our point is don't permit it. And if this gets continued, I will provide the board with the calculation of the parking they need that they don't have, which will clearly demonstrate why the site plan for parking purposes is woefully inadequate. Thank you, Mr. Chairman.
Thank you.
And just to respond to that, the site plan we acknowledged at the prior we would go back in for another use when the special permit. You get back into the chicken and the egg. We have to take one step before we can take another. Mr. Souza's in on his special permit, and that could be conditioned on the site plan approval. But I also just want to reiterate that Attorney Dennehy is speaking on behalf of Mr. Field and the dumpster storage, which has been going on for 11 years with no direct access and with no special permit until more recent history. There's been 4 years since a cease and desist order was issued on that. So I understand that this is a different situation, but I do want to just reiterate that we are working hard on getting everything satisfied before the board and getting the approvals that are required. But we do have an active site plan approval. We do have sufficient parking for all of the uses that are there. And the site plan, to the extent that it needs to be changed, isn't before this board. There is an underlying site plan that was approved and on which the temporary occupancy is based. And the process is going through the way that the zoning law and the way that zoning boards are set up to hear them and to allow things an opportunity to proceed. So we're just asking the board to reverse the building inspector's letter.
All right, thank you. Chris, you have anything else?
No, I don't.
All right. Arthur, anything?
No, nothing further.
All right. I'll go to Alex. Would it make sense to continue this?
I think it would, Mr. Chairman, if the applicant is amenable to that. And again, Matthew, do you have a sense of where we're at with the 100-day calculation with this application?
Yeah, it's basically the same or within a day. It was submitted, I think maybe like the day before, the day after or something. So it's virtually the same. So the deadline would be like something like maybe April 23rd or within a day or two of that, I think.
Attorney Kona, would you be amenable to pushing this to the 17th and granting any extensions we need?
Yes, we would agree to that.
Okay, what was it,
All
Alex?
right, great. And if I could just request that Attorney Crowe just send a quick email to Mr. Hines, just acknowledging that continuance, we'd appreciate it.
Yes, be happy to.
Okay. Chris, you okay with continuing this?
I'm okay with all of it. Now it doesn't matter which let me rephrase that. Does it matter which one of these matters we hear first procedurally? Would it benefit? Obviously, they're both the same. Being Attorney Bonner, does one pivot on the other? Would we need to hear one matter before the other one? Because they're both involved.
I think the order we went today would probably be fine.
Okay. I just, it's a tough situation as it is. I just like to make sure procedurally everything goes the way it's supposed to go. And we're not caught up in any more red tape and unnecessary instances.
Okay.
I understand.
Makes sense. Arthur, are you okay with the continuance?
Yeah, I don't have a problem with it.
Okay. And then I'd ask maybe if Attorney Cronin and Attorney Dennehy, if you have anything to submit regarding this parking, I might like to see that.
I'll be happy to provide it 10 days in advance so that the board has an opportunity to review it. Thank you, Mr. Chairman.
Okay. So make a motion to continue this hearing to May 17th. At what time, Matt? Or 7:30?
Yeah, just a question of how much time you want to give the first one. So I'd suggest 7:30. It's up to you.
Okay, so make a motion to continue this hearing to May 17th at 7:30 with an additional 14 days to issue a decision from that date. Get a second.
Okay.
Chris McGrail, second.
I do a roll call vote. All those in favor? Frederick Cassavan, aye.
Arthur Boyle, aye.
Chris McGrail, aye.
All right, thanks, everybody. We'll see you on the 17th.
Thank you.
You didn't.
Okay, we have. Falcone, okay. The notice is hereby given the Pembroke Zoning Board of Appeals will hold a public hearing on Monday, March 29th, 7:30 p.m. on the application of Fred and Jessica Falcone, 359 Center Street, Pembroke, Mass, requesting a special permit in accordance with the zoning bylaws, town of Pembroke, section Roman numeral 41B4, to construct an attached dwelling unit in-law apartment as part of an addition to the existing single-family house, property at 359 Center Street, Pembroke, Residence District A. All right, who's here for that?
I'm here, Jessica Falcone.
Hi, Jessica. Why don't you just tell us what you're looking to do?
Well, we're just trying to add on an addition to our existing raised ranch. On the lower level, it would be an in-law apartment for my father, and on the upper level would just be a bigger living room for us.
Okay. How big is it going to be?
Well, the in-law apartment would be 503 square feet, I think it is.
Okay. Chris, do you have any questions for the applicant?
I don't think I have any questions. What was the only the issue at hand? Was that it was in the flood zone, for lack of better terms?
No, we don't have any issues with the flood zone here.
No, not there's another word for it. But okay, yeah, no, I mean that. Matthew, go ahead.
Oh yeah, Chris. Yeah, I think you're referring to the, what do they call it, the floodplain protection. Now I'm forgetting myself. Basically the floodplain protection district, or I'm forgetting the term, but I think that's not a problem. That's just kind of stating what zone it's in, or the overlay. I think that's not a problem, in terms of the actual application or the situation.
Okay, yeah, I might have just misread it in the application. Yeah, no, it's around 520 square feet on the bottom floor, and then another just over 350 upstairs in the
right. Yeah, that sounds about right. It won't be as big upstairs, so yeah, that sounds right.
Yeah, I mean everything. I don't have any questions. Everything seems all right.
Arthur?
The only thing I see is, a deed restriction on it that, when the use changes, that it be changed back to a single family.
Those are what you're talking about, the conditions in the bylaw?
Yeah, that would be a good way of doing it, is right.
Yeah, okay. So yeah, they're applying under that section of the bylaw, so I guess we can condition it, but it's subject to sub 4 A, B, C, D, and E, which it looks like they meet here. And just Mrs. Falcone, just so you know, the property needs to be used for family.
Right.
The in-law, that's all.
Yes, it will be.
Either by blood or by marriage. So.
Yep.
I think Chris I'm fine with it. Anyone else have any other questions?
No, I'm fine with it.
All right. And Mrs. Falcone, do you have anything else you want to add before we close and vote?
No.
Was anyone, Matt, in favor or against the project from the public? Any letters, anything like that, calls?
I got a call from a neighbor today just asking about it, but he didn't have any opposition to it. Let me quickly check the file.
Okay.
I don't think there's been anything else.
Okay.
No, nothing.
All right. We'll make a motion to close the hearing so we can go into discussion and a vote.
Second.
All those in favor, roll call vote. Frederick Cassavant, aye.
Chris McGrail, aye.
All right, that's 3 ayes. All right, gentlemen, I think sounds like we're all in agreement. We can allow the application based on the plan submitted, and it'll be subject to section 41B4, the conditions listed in the bylaw. You guys, that makes sense to you guys?
Yeah.
Okay.
Yeah.
All right, we'll make a motion to allow the application of Fred and Jessica Falcone, application 6-21, for a special permit pursuant to section Roman numeral 4(1)(b)(4) of the bylaw, based on the plan submitted with the application and subject to the conditions contained in said section of bylaws A through E. Get a second?
Second.
All right, all those in favor? Well, any discussion?
No.
Okay. All those in favor, roll call vote. Frederick Cassavant, aye.
Arthur Boyle, aye.
John Monroe.
That sounds like 3 ayes. So Ms. Falcone, you're all set. You can just coordinate with Matt on getting the decision, and then you can from there work on your building permit.
Okay, thank you very much.
Good luck. Thank you.
Thank you. Take care.
Thank you.
And now we can reopen, I believe, so we can reopen case 4-21. Attorney DeLisi was looking for an continuance. Is Attorney DeLisi here? I think I see you.
Hi, Rick, he's coming in. I just he's coming in. Sorry, my mistake.
Hello.
Attorney DeLisi, you were looking for an just a continuance?
Yes. Hi. I'm sorry about that. I seem to be having connectivity issues on my end.
No problem.
Yeah, we submitted a letter. We're going through the planning board process. There really is no proposed change to the buildings or the pavement, which are the reasons why we've requested a variance. However, I think it's probably prudent just to wait another couple of weeks to see where the planning board's at with this application.
Okay. I'm fine with that. Chris, you okay with the continuance?
Yes, I'm fine.
Arthur, you okay with the continuance?
Yes, sir, I am.
Okay, I don't see, okay, we can just continue it to then and we can hear more testimony at that point. So we'll just make a motion to continue case 4-21 to April 26th, 2021. Matt, what time should we put it on for? Do we have stuff already on there?
No, that one's wide open, so I should just 7 o'clock.
Make them 7 o'clock. Get a second?
John Warner seconds.
Chris, can you second that motion?
Oh, yeah, Chris McGrail, second.
Okay, all those in favor, roll call vote. Frederick Cassavant, aye.
Arthur Boyle, aye.
John.
Chris McGrail, whatever.
Okay. All right, council, you'll be on for the 26th.
The 26th of April.
Yep.
Okay.
7
Thank you
p.m.
very much. I appreciate it.
Thank you.
You're welcome.
All right, Chris, you got this last one?
Yes.
Okay. All right, gentlemen.
Have a good night, Rick. Time is it?
8:07.
8:07. So we got a few minutes till the next one comes in. I'm just going to stay on the line, just review some of the stuff.
If it helps the chairman, we were going to ask for probably a continuance, only because we were going to provide the board with some conditions, and I have to admit, I unfortunately was not able to get it to the board in a timely fashion. So if that helps the board understanding tonight's meeting, I'll make sure I have it to the board the next scheduled meeting.
I think it does help, but Matthew, correct me if I'm wrong, we may have to wait till 8:15 to do so.
Yeah, so two things. We should wait till 8:15.
Yeah.
And also, I think with this one, again, this similar thing, it was submitted, I think, like April 13th or so. So we're up on them because it's requesting a variances. We're up on the 100-day deadline, I believe, very soon. So if Attorney Danny is willing to, I guess, basically sort of agree, just as we had those other attorneys agree for their applicants to extend the deadline, maybe 2 months or what have you. I guess.
I'll provide you a letter in writing, Matt, to that effect too.
Okay, yeah, and if you can verbally agree as well.
I'll verbally do it, but I'll also provide writing too for you.
Yeah, both would be great. So yeah, I guess we just wait about 7 minutes. In the interim, if you want to, you know what I'm about to say. If you want to approve the draft minutes for.
Oh yeah, draft minutes, right on.
Did I give you?
Oh, what did I just do?
Mhm.
Push the button. Hello.
I can say
Hey,
that.
hey, Chris.
I don't have anything in front of me. I'm doing this off of my iPhone. I have gone over the minutes. I'd like to pass a motion to, I'd like to present a motion to approve the draft minutes of the previous Pembroke Zoning Board of Appeals meeting. Correct me if I'm wrong, the date was March 9th.
So there are actually 3 of them because I also did 2 for the River Marsh hearing. So it's January 12th, March 9th, and March 15th.
Okay, I'd like to pass the motion to approve those minutes as Matthew just reiterated. At this time, can I get a motion, a second?
Second, John Gordon.
All right, put it to a roll call. Chris, to pass the minutes, Chris McGrail, aye.
Matthew Boyle, aye.
John Gordon, right?
All right, thank you.
Thank you.
I gotta get a new laptop. This the iPhone's not cutting it.
Joys of technology, I guess.
To be honest, I didn't need it until I started hanging out with you guys. I was doing just fine.
I like the in-person stuff.
Oh, I mean, not saying I don't know what I'm doing, but I mean, talk about trial by fire. Just not even really. I think I've sat down with Matthew. That's the only one.
Yeah, it's funny that I think the only people this benefits are sometimes we have applicants, attorneys, and people who are based in Boston or Plymouth or wherever, sometimes even further. And sometimes for them, it's the Zoom is quite convenient. They don't have to travel all the way to Pembroke, drive through rush hour, drive home. Some of the engineers are based way out in other places. But I think for everybody else,
I got like 3 different things: Zoom, GoTo, Microsoft meetings. I can't keep up with them.
yeah, no, I think for everybody else, people would much prefer. I mean, I live just in Marshfield, only 10-minute drive from here. I think obviously everybody else lives in Pembroke only, so I think most people would definitely prefer just to come here physically. It's so much nicer when you're all in the same space. You can make eye contact. You have that interaction.
That's me.
Are there any hopes of that, or any? I know there's hopes, but is there any talk of said activity?
Not really, but I would imagine by it can't be too long now. I mean, I would think within 2 or 3 months, everybody who wants to be vaccinated is going to be. It would seem like. I mean, in our country, we're actually fairly lucky in that regard. We're ahead of most other countries in the world. And so I would guess by July, I would think if not sooner, we'll probably be back to in person. But we'll see. I mean, I guess that that the variants are a question. If do the vaccines work on the variants? Are we going to need to be vaccinated again?
Mm.
I love your optimism, Matt.
Sorry, Ken, what did you say?
I said, I love your optimism.
I get it from my father. always see the dark side, I guess, or the negative.
Shut down. Okay.
All right, Matthew, how are we looking? Attorney Denny, I know you're with us. Do we have anybody else that we're waiting on?
I don't think so. I don't see anybody in the waiting area, so.
All right, I'll bring it up. My name is Chris McGrail, the interim chair of the member this meeting of Pembroke Board of Appeals, case number 1-21, variance applicant Jeffrey Perrette, Old Salt Realty Trust, property 37 Mattakesett Street, continued from February 22nd, 21 and March 15th, 2021. Is now open, and I'm going to bring it to Attorney Dennehy.
Thank you, Mr. Chairman. Mr. Chairman, fellow board member, we're requesting tonight a continuance to the next convenient date to the board. As reason is that I had indicated to the board last time that I was going to submit some conditions that the draft that the board could take a look at. I unfortunately was unable to get that timely to the board, and I would ask a continuance. In doing so, I'd also acknowledge and accept that if we end up going beyond the mandated 100 days for a decision, that we agree to extend to afford the board the opportunity to hear another hearing, further information, as well as to afford the board the time to render its decision. If it ends up being beyond the 100 days, that we agree to it. So I just wanted to put that on the record, Mr. Chairman. I will provide the board with a written letter to that effect also.
Yeah, send Matthew over an email and your verbal agreement. Arthur, John, do you have anything on that? Any thoughts?
I have no problem, Chris.
No, I'm all right with an extension.
I agree as well. I'd like to pass a motion to such effect. We got to agree on a date. Matthew, do we have a date?
Yeah, I guess either April 26th or May 17th. I guess sooner is probably better if that's okay with Mr. Attorney Dennehy.
Either date's fine with me. If the board would like the 26th of April, that's convenient.
See, I'd suggest April 26th at 7:15, I guess. And I guess if Mr. Dennehy can just verbally confirm that he'll grant the extension until that date, plus the 14 days to issue the decision.
I so accept, and yes, indeed, verbally, we accept to continue to the 26th and allow the board an additional 14 days for any decision thereafter.
All right, thank you. I'd like to pass a motion to such effect to continue case 1-21 until, was it April 26th at 7:15?
Correct.
So moved, Mr. Chairman.
All right, we take a roll call vote. All right, we get a second to take a roll call vote. Chris McGrail, aye.
John Gorney,
Arthur
right?
Boyle, aye.
All right, great.
Thank you, Mr. Chairman. Thank you, fellow board members.
Thank you, Attorney
Thanks,
Denny.
John.
We got anything else? We're all good, right, Matthew?
I think you're all set. You approved the minutes. I can't think of anything else, nothing else written down. So I think we're all set. And as I was mentioning before, it looks like we can cancel the date of April 5th, which I had down there kind of tentatively. That's it looks like we don't need that. And so I guess the next regular hearing or the next regular meeting of the ZBA will be April 26th. And then
Sounds good.
River March somewhere in between there.
River March on, is it April 13th, I believe is that one.
All right, cool.
Good. Thank you.
All right, Matthew, Don, have a great night.
Great, okay.
You too, Chris.
And have a good night, guys.
All right, take care.
Arthur. Take care, guys. Good night.
Good night.
Take care.